Let's take a look at who is entitled to FMLA. Leave policies are one of the major ways in which the work-life conflicts of employees can be addressed. What does the law require in terms of leave policies? The Family Medical Leave Act, known as the FMLA, is the main federal law governing the provision of leave for employees for parental or medical reasons. All government agencies, regardless of their size, are covered by this law, as are private sector employers with at least 50 employees. The FMLA provides a minimum standard for the leave policies of covered employers. Parental and medical leave policies must be consistent with the provisions of FMLA outlined here, although employers are free to exceed the law's minimum requirement. Entitlement to FMLA leave depends on a number of factors, including the size of the employer, the duration of the employee's tenure with that employer, the number of hours worked by the employee in the 12 months before the leave. Leave is also granted based on the occurrence of a qualifying event for which the leave is needed, and provision of adequate notification to the employer of the need for the leave. The employment duration and hours requirements must be met as of when leave would commence rather than at the point in time which leave is requested. So, an employee cannot be deemed ineligible for leave that would commence in the future simply because the duration or hours requirement is not currently met. In a case involving a part-time radiological technician, the court allowed the employee's FMLA claim to proceed even though the employer's timesheets showed that she had worked about 65 hours less than the 1,250 hours required. The reason was that she could show that the time spent each day prior to her shift preparing equipment for use and the time spent at her employer-mandated continuing education courses were work hours that should have been counted. In contrast, a mail handler worked 1,248.8 hours in the preceding 12 months and was lawfully terminated for absences that might have been covered by the FMLA. Her argument was that a 2-hour suspension administered a month before her termination should not have been considered and was rejected because she had failed to file a timely grievance challenging the suspension. Tallying the number of hours worked during the past 12 months is not always a straightforward proposition.